2012, the preclearance provisions blocked Texas from enacting a discriminatory redistricting map, and they blocked a very strict voter ID law that would have effectively disenfranchised hundreds of thousands of Texas voters, mainly Latinos, African Americans, and Asians. Let me say one thing. The Voting Rights Act, it's not about political parties, and it's not about politicians, and it's not about candidates. It's about the opportunity to give voters a chance to elect the candidate of their choice, someone who will allow their voices to be heard in a district where their vote will count. Today, the Supreme Court has turned its back on those voters who are disenfranchised. They've gotten rid of that umpire, that referee who, whether it was a Democratic Justice Department or a Republican Justice Department, who through the years has served as that umpire, that referee. That decision has essentially taken away that safeguard in states with histories of discrimination. And I urge my colleagues on both sides of the aisle to develop a system that takes the voting rights of Americans into account and protects them and safeguards them as one of the most basic and fundamental rights of any American. Thank you so much for being here.
For those of you who may not be aware, since 1982, approximately 2,400 discriminatory voting changes have been blocked as a result of Section 5 objections. And today, with this decision, the Supreme Court chose not to acknowledge any of that information, nor the success or the effect Section 4 or 5 has had on our democracy. We have been joined by our whip, Mr. Hoyer.
Thank you very much, Congresswoman Fudge, the chairman of the Congressional Black Caucus. I join the members of the Asian Pacific Caucus, members of the Hispanic Caucus. But this is about all Americans, not just particular Americans. Particular Americans are protected, but in a real sense, it's about all of us and the kind of country we are and want to be. Today's ruling is a disappointing blow to voting rights in America and will have a real impact on voters. In 2006, this Congress, in which I served, reauthorized the Voting Rights Act in a bipartisan fashion and under a Republican president. Significantly bipartisan support, overwhelming. There was a broad consensus then, as I believe there still is today, that Sections 4 and 5 of the Voting Rights Act were both responsible and necessary answers to the lingering problems of discrimination at the ballot box. If anybody thinks there are not continuing efforts to make voting more difficult for some people, they haven't been reading the papers, listening to the radio, watching television, or, frankly, listening to what's going on in America. In America, no state or local authority should be able to make it easier for some people to vote and harder for others. In America, nobody should have to march for their most fundamental right, the right to vote. John Lewis, an extraordinary American, beaten, bloodied, almost died, marching for voting rights, March 7th, 1965. Here we are, some 60 years later, 50 years later, almost. And the Supreme Court says the problem no longer exists. The formula needs to be reworked. We marched across the Edmund Pettus Bridge 10 times together to memorialize how much work it took to get the Voting Rights Act passed and highlights its relevance and importance to this day. The first time John marched, he nearly lost his life, as I said. Americans responded that that's not what they thought America was about. The ballot is the instrument by which our republic is sustained, and Congress has a duty to protect ballot access and expand opportunities for all eligible Americans to vote and have their votes counted accurately. Today's ruling is a setback, but Congress still has a mandate and a responsibility under the 15th Amendment to the Constitution to secure and protect the franchise for all Americans. Let me quote that provision of our Constitution. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have power to enforce this article by appropriate legislation. Very frankly, in 1965 and subsequent reauthorizations, the Congress took that responsibility very seriously. And as I said, with Jim Sensenbrenner as chairman of the Judiciary Committee and in the lead, overwhelmingly passed the 2006 reauthorization. After thousands of pages of testimony and findings, which the Supreme Court, in a 5-4 decision, has essentially set aside. The 113th Congress must make addressing today's unfortunate decision a top priority. And that's why Democrats and Republicans, as we did in 2006, ought to come together to begin a process that ensures political jurisdictions with a history of discrimination cannot impose new barriers to ballot access. I came in when Pete Gallego was talking. He talked about the significance for a lot of the people that he represents. And I suggested at the beginning all of the people that he represents. So I'm looking forward to joining with those on this platform and those in Congress on both sides of the aisle to make sure that America is what we say it is, a land for all with opportunity for all and protection for all to cast their ballot. And now it's my privilege to yield to my friend, the assistant leader. He's already spoken. I'll yield to Marcia Fudge, who knows what's going on.
Thank you. We will now be joined by the co-chairs of the Civil Rights Task Force of the Congressional Black Caucus. In this order, we would have Representative John Conyers and Representative John Lewis.
When I first came to Congress, I went immediately to the Speaker of the House, John McCormick, and asked to go on the Judiciary Committee. And the reason, as he and I both knew, was the Civil Rights Act that was so important. But today, Citizens United has been eclipsed by the decision in the United States versus Shelby and Holder. This case takes us back to the Civil Rights Act of 1866, which didn't give African Americans the right to vote. And then we went into 1869 when the 15th Amendment did give African Americans the right to vote. And then with the 24th Amendment, poll taxes were outlawed in 1964. And then in 1965, President Lyndon Johnson signed the Voting Rights Act into law, permanently barring barriers to political participation by racial and ethnic minorities, prohibiting any election practices that denied the right to vote, and requiring jurisdictions with a history of discrimination in voting to get federal approval before the changes in election laws can take effect. And what the Supreme Court has done with the ruling that was issued only hours ago is to obliterate that collection of jurisdictions that were under review. And so the Voting Rights Act, signed by Lyndon Baines Johnson in 1965, then by President Nixon, President Ford, President Reagan, and President Bush, have all signed them. And this is what makes the bipartisanship of where we dust ourselves off and start all over again becomes so important. We can rise to this challenge. We don't have any alternative. And it is up to us to see that we remedy this in as meaningful, as fair a manner as possible. There were members on the Supreme Court that wanted to take out Section 5 while we were at it. And I can't remember who it was that restrained that from coming in too, but our job is big enough as it is. This is a day from which we will be planning, strategizing, working with both bodies of the legislature and, of course, everyone in every party to get this right. It's been done before. We've faced challenges like these, but the Voting Rights Act must be continued. I haven't heard anybody say yet that we don't need it. Obviously, the record is replete with those that have been challenged or actions taken that have prevented it from happening. And so I join these members, of which we are only a small number, but I think that we're up to the task. We've got to be up to the task. This may be the most important civil rights action that we take.
Thank you, Madam Chair. Today, the Supreme Court stuck a dagger in the heart of the Voting Rights Act of 1965. They're saying, in effect, that history cannot repeat itself, but I succumb and walk in my shoes. As Justice Ginsburg described in her dissent, the history is relevant because voting rights have been given in this country and they have been taken away. After the Civil War, slaves were given the right to vote by a constitutional amendment. They were elected to Congress and served in this body. After a few short years later, those rights were nullified, and one of the worst, most brutal periods of discrimination and human and civil rights violation followed those decisions. It took exactly 100 years, from 1865 to 1965, to get those rights back. A nation turned a blind eye to legalized segregation and racial discrimination for 100 years. It took organizing people who feared for their lives. It took standing in unmovable lines. It took people struggling and dying for the right to vote. Just 49 years ago, 3 young men that I knew, on June 21st, 1964, Andy Goodman, Mickey Schreiner, and James Shaney went out to investigate an African-American church that was burning, a church that had been used for voter registration workshop. They were detained by the sheriff, later taken out of jail, beaten, shot, and killed by the Klan. We don't want to go back